Hello folks, and welcome to the first of what I'm calling Lockdown Law, a family law update during the coronavirus lockdown. If at the end of this you have enjoyed what you hear, then please circulate it amongst your colleagues or share it on Facebook, Twitter, or any of the other options that there are these days. And if you want me to give an update in relation to a specific area of family law, then email me at dstuart, that's Stuart, at 14fourtwn.co.uk, and I'll see what I can do. Anyway, today I'm going to be talking about the evidence given by children and other vulnerable witnesses in family proceedings, particularly those under the Children Act 1989. What I'm going to be talking about applies equally to care and private law proceedings in the main. Now, of course, we know that in Re W, the 2010 Supreme Court case, the leading case in this area, the Supreme Court endorsed the suggestion that the question of whether a child should give evidence in Children Act proceedings should be considered at the earliest possible opportunity. An early hearing within private law proceedings, or case management hearing within care proceedings. Now, much as some have always been uncomfortable with children giving evidence within Children Act proceedings, we must always remember that this is not unusual in the criminal courts. And indeed, I think our criminal cousins consider our squeamishness about this to be a little bit unusual. It's important to bear in mind what Lady Hale said in Re A in 2012, where she held that the court's only concern in family proceedings is to get at the truth. She said the object of the procedure is to enable witnesses to give their evidence in the way that best enables the court to assess its reliability. It is certainly not to compound any abuse which may have been suffered. Well, so much for that. Now, let's look at what the court has to consider when faced with an application for a child to give evidence. The gateway is contained within section 96, subsection 2 of the Children Act, which provides that the child's evidence may be heard by the court if, in its opinion, he understands that it is his duty to speak the truth and he has sufficient understanding to justify his evidence being heard. In Re G and E, Children Vulnerable Witnesses, 2011, Mrs. Justice Porfley described this as the competence test, which in essence opens the door for the discretionary exercise. The competence test may be considered by the court by reference to a range of pieces of evidence, which include, but are not limited to, the way in which the child responds to the so-called truth and lie questions at the outset of the Achieving Best Evidence interview, expert evidence such as that from a psychologist or a psychiatrist, and indeed in Re G and E, Mrs. Justice Porfley had the benefit of both a psychologist and a psychiatrist when determining whether the child in that case should give oral evidence. And the court may also have reference to evidence from the children's guardian. So moving on to the discretionary exercise, there's been significant development of the jurisprudence over an extensive period of time insofar as this is concerned. However, it is unnecessary for us to consider anything that went before the Supreme Court's decision in Re W, save to say that prior to them, the approach that was taken was that was set out by Lord Justice Smith in LM and Medway Council and others in the Court of Appeal in 2007. Where he said the correct starting point is that it is undesirable that a child should have to give evidence in care proceedings, and that particular justification will be required before that course of action is taken. There will be some cases in which it will be right to make an order. In my view, they will be rare. And judgments that have been given by Lady Justice Butler Sloss as she then was, Lord Justice Wilson as he then was, Lord Justice Wall as he then was, and Lord Justice Thorpe, all of whom said that in their years of High Court experience, which, let's face it, if you think about the four names I've just mentioned, must have been a considerable number of years of experience, so that they had never seen a child give evidence. You might think that's quite extraordinary these days. Times really have changed. And that is particularly so when we look at a decision from a few years ago from the current president of the Family Division. So what are the key points to take from REW? Well, Lady Hale told us that a rebuttable presumption against a child giving evidence cannot be reconciled with the approach of the European Court of Human Rights, which always aims to strike a fair balance between competing European Convention rights. That is something that social workers and children's guardians, all of whom undoubtedly are seeking to protect children from the rigours of cross-examination, sometimes need to remember. Lady Hale went on to say Article 6 requires that the proceedings overall be fair, and this normally entails an opportunity to challenge the evidence presented by the other side. Striking a balance in care proceedings may well mean that the child should not be called to give evidence in the great majority of cases, but this is a result and not a presumption or even a starting point. And it was that led to Lady Hale's two-limb test. The first being that the court must look, when deciding whether or not a child should give evidence, to the advantages that it will bring to the determination of the truth. And secondly, the damage that giving evidence may do to the welfare of the child. Now, in terms of the first of those limbs, Lady Hale told us that when looking at the advantages that the child giving evidence would bring, we must consider the following. Firstly, whether it is necessary for the findings to be made in order that the case may properly be determined. So if the issue that the child is giving evidence on is a side issue, is not one that threshold will turn on, is not one that the welfare decision will turn on, perhaps the child doesn't need to give evidence. Secondly, she said, the quality of the evidence that the court otherwise has. And insofar as that's concerned, we might look at whether there are any other witnesses, eyewitnesses perhaps, or people that the child has spoken to in the past. Thirdly, Lady Hale said that we must look at whether there is sufficient other evidence without the child being cross-examined. She said sometimes little or nothing can be gained from a child being cross-examined orally, especially where there are simply generalised accusations of lying. And use of that word lying is something I'm going to come back to later. Lady Hale said we must look at the quality of the ABE interview, the age and the maturity of the child, and the time that has elapsed since the events in question. The longer the time, the implication being, the less likely it is that the child will be called to give evidence. Then in terms of harm, the second of the two limbs, Lady Hale said we must consider the following. Firstly, the age and maturity of the child, together with the length of time since the events in question. Secondly, what support from the family or other sources the child has. That might include school, it might include a foster carer, it may include someone outside of those areas. So in effect, if this child is going to give oral evidence, what are they going back to? Where are they going to get the emotional support from afterwards? The child's own wishes and feelings about giving evidence. And Lady Hale said that, in her view, an unwilling child would rarely, if ever, be compelled to give evidence. Lady Hale said that we should look at the views of the children's guardian and where appropriate, those with parental responsibility. We must look at the risk of delay. We must look at the potential damage if the child is not called, especially as the family court has to give less weight to the child's evidence in those circumstances. And we must look at any risks to the specific child in the individual facts of that case. Paragraph 27 of REW, Lady Hale added the following: "It does not assume that the most reliable account of any incident is one made from recollection months or years later in the stressful conditions of a courtroom. Nor does it assume that an Old Bailey-style cross-examination is the best way of testing evidence. A family court would have to be astute, both to protect the child from the harmful and destructive efforts of questioning and also to evaluate the answers in the light of the child's stage of development." Incidentally, in another case, Mrs. Justice Porfley said that the two-limb test could be applied when looking at whether a vulnerable adult witness should be called to give evidence. Now, earlier I mentioned that the current president of the Family Division, Sir Andrew McFarlane, had weighed into this debate a few years ago. When he was Lord Justice McFarlane, sitting in the Court of Appeal in the case of Ree, a child, in 2016, Sir Andrew gave what he described as a firm reminder to courts to follow the guidelines within REW. In a judgment which many saw as a reminder to those of us in the family courts that we shouldn't be, to use the phrase I used earlier, as squeamish as we can be about children giving evidence, he added the following: "As is well known, children, even children of a very young age, who have made allegations of abuse which are subsequently the subject of criminal proceedings, are required to give live evidence within the criminal process. It is understood that some 40,000 do so during the course of each year. The child will typically be protected from full exposure to the courtroom by the use of special measures, for example, answering questions over a video link. Conversely, for many years, the practice and culture in family proceedings was that such children, even if aged in their late teens, would never be required to give live evidence in the family court." Well, that brings us on to the measures that can be put in place when a child or other vulnerable witness gives evidence. Measures which can help to reduce the potential harm to them going through the process, and so measures which are, I would suggest, relevant to the second of Lady Hale's two-limb test in REW. Now, at paragraph 28 of REW, Lady Hale said, "The important thing is that questions which challenge the child's account are fairly put to the child so that she can answer them, not that counsel should be able to question her directly. One possibility is an earlier videoed cross-examination as proposed by Pigott." That was, of course, the report on the advisory group on video evidence from 1989. Lady Hale went on to say another is cross-examination via a video link, but another is putting the required questions to her through an intermediary. This could be the court itself, as would be common in continental Europe. Now, there is a range of advice coming from research and guidance to the judiciary, both here and abroad, that we ought to touch upon and look at that development over the course of the years. Studies in the noughties by Plotnikoff and Wolfson interviewed some 394 young witnesses in criminal proceedings. Over half said that they did not understand some of the questions that they were asked. And you might say that was only the half that knew that they hadn't understood some of the questions that they had been asked. But we need to look at other factors as well. According to the Department of Children's Schools and Families in 2008, about half of socio-economically disadvantaged children have speech and language skills that are significantly lower than other children of a similar age. 10% of all children have a recognised mental disorder, and 1% of all children are on the autistic spectrum. Consequently, there's a significant number of children who have some form of communication difficulties. This may go some way to understanding the difficulties that some children have in terms of understanding cross-examination. But moreover, it's a warning flag to those of us conducting cross-examination about how we do so. Judges are encouraged to explain to a child that they should say if they don't understand the question. They've been told that since the Equal Treatment Bench Book of 2009. But sometimes a child might not know that they don't understand the question, or they might be embarrassed about saying that they don't understand it. According to Spence and Lamb, more than 50% of children do not tell the court when they have difficulties. The Achieving Best Evidence in Criminal Proceedings guidance from 2011 identified that 5% of young witnesses suggested that lawyers were sarcastic, rude, aggressive, or cross. Terms that they used included bullying and badgering. And therefore the court has to be particularly careful in this regard, both at the stage of the ground rules hearing and during cross-examination. And it's also important that we, the advocates who are presenting our cases, representing our clients, conducting the cross-examination, are sensitive to this as well. Apart from anything else, if we're hectoring young witnesses or vulnerable witnesses, if we feel or are seen to be bullying them or badgering them, we're less likely to get the best evidence out of them. They're more likely to put up the barriers and not give the best evidence. And, dare I say, we're also likely to lose the sympathy of the court. And in 2012, the Judicial College published guidance about ground rules that should be laid down. Those included adapt questioning to the child's stage of development, ask short, simple questions, one at a time, follow a logical sequence. We might now add that having separate topics and signposting those topics should be included, including saying, I'm now ending that topic, I'm moving on to ask you about whatever. We should speak slowly and allow the child enough time to answer. We should avoid tag questions. And we should avoid allegations of misconduct with the child or vulnerable witness unless there is good reason to do so. It's interesting to look at some of the examples from abroad. The examples that have grown up in Western Australia over the years are particularly helpful, I would suggest. Now, in Western Australia, the norm is for an ABE-style interview to be followed by evidence being given either via a video link or being pre-recorded. The Children's Witness Service, which as far as I can tell is a little like an intermediary, will advise the judge or counsel of relevant factors, including the child's special needs and family circumstances. Guidance to counsel in Western Australia includes the following. A, the counsel should address the child by the name they prefer, often their first name. Questions should be short and simple, perhaps going back to Mrs. Justice Parker's 10 words or less rule. Thirdly, the witness should be given adequate time to answer the question. Fourthly, and following on from the third, answers should not be interrupted. The tone of the question should not be intimidating, annoying, insulting, or sarcastic. Legalese should be avoided and vocabulary should be age appropriate. A young child should not be accused of lying. Instead, they say, perhaps with some understandable reason, that the words incorrect or wrong are preferable. Counsel should avoid repetition or mixing subjects. And finally, they say that in cases where the witness is clearly incapable of answering questions, counsel should consider varying the approach or indeed abandoning the cross-examination altogether. And very recently, in fact last month, in May of 2020, in the family court, His Honour Judge Middleton Roy was considering a case where a parent had autism. That case has been reported on Bailey as Re D and E, Parent with Autism, 2020 EWFC B18. And within that, Judge Middleton Roy gave some very helpful advice when a witness with autism is giving evidence. And it may be that you would consider that some of what he said applies equally to children giving evidence, or indeed adults who have other vulnerabilities giving evidence. Now, specifically to autistic witnesses, Judge Middleton Roy said that they may have some of the following difficulties in court. A. Sensory overload. B. Difficulty answering hypothetical questions. C. Difficulty with chronologies and timescales. D. Expectations. E. Settlement discussion and mediation. F. Difficulties with any lack of continuity. For example, with counsel, judges, or even the environment in which they're attending for hearings or giving evidence. And G. Unwritten rules. And the example that Judge Middleton Roy gave was the rule about when to speak in court and when not to. Judge Middleton Roy acknowledged that every person is different. Every person has different needs, different vulnerabilities. And he acknowledged that every person who is on the autistic spectrum has different strengths, different vulnerabilities, different difficulties. But he said, with reference to the Equal Treatment Bench book, that the following might be helpful with autistic parties and autistic witnesses. And again, I say that some of this would be relevant when looking at children as witnesses or adults with other vulnerabilities. He said, it's necessary to give very explicit instructions on all case management directions. We should aim to keep the same judge at all preliminary hearings. We should explain in advance what the hearing procedure would be. Provide a written timetable. Explain that parties can visit the court beforehand for a look around. That a private conference room should be reserved and the party should be told that that will be arranged so that they're not coming to court in a flap. They're not coming to court with that extra anxiety. He said that we should provide a simple chronology personal to that individual rather than the more generalised broad brush case chronology that there otherwise would be. The procedure should be explained at the outset, including when breaks should be, and that breaks should be provided every 60 minutes for 10 minutes on each occasion. The judge said that it was necessary to arrange appropriate setting for where the person will sit and to provide them with an escape route. That people should be prevented leaving or entering the room or moving behind that individual. That heaters, fans and unnecessary lights or anything that's going to make an unnecessary noise should be switched off. That's particularly important for those who have sensory overload. There should be ground rules established in terms of the style of questioning. We should avoid figurative language, such as take a seat. Hypothetical questions should be avoided, and we should also avoid legal jargon. Well, I hope that some of that has been helpful to you. As I say, if you find it helpful or interesting, then please send the link to your friends or share it on Facebook, Twitter, or any of the other social media platforms. And if there's any subject that you want me to cover in a future Lockdown Legal, then email me at dstuart, that's Stuart, at 14, the word rather than the digits, .co.uk, or tweet me at Damian, Damian, A Stuart. Good night.